Ladies and gentlemen, welcome, and thank you for joining today's live SBA web conference. Please note that all participant lines will be muted for the duration of this event. You are welcome to submit written questions during the presentation, and these will be addressed by Deborah Crumity during the Q&A. To submit a written question, please use the chat panel on the right-hand side of your screen. Choose All Panelists from the Sent To drop-down menu. If you require technical assistance, please send a note to the event producer. I would now like to formally begin today's conference and introduce Chris Eischen. Chris, please go ahead.
Thank you, Carla. Hello, everyone, and welcome to SBA's first Wednesday webinar series. Today, we are focusing on SBA size regulations and affiliation, and by the end of today's session, you should have a better understanding of this topic as well as the resources available to you. We appreciate you taking this time to join us on the April edition of SBA's first Wednesday webinar series and hope you find this information beneficial. Now, if you are new to our event, this is a webinar series that focuses on getting subject matter experts on specific small business programs, in this case, SBA size regulations and affiliation, and having them provide you with valuable information you can use in the performance of your job as an SBA employee, a member of the federal acquisition community, or a PTAC employee. We periodically get emails asking if small business concerns can be invited to participate in the First Wednesday program, and unfortunately the answer is no. The training you are about to receive is focused on you and is not applicable to small business vendors. SBA hopes to directly train these small business concerns through other methods. Now I'm just going to give you a little brief background on the First Wednesday program. The program was initially created for contracting staff, which is why the training was called 1102 First Wednesday. The 1102 designated government series for contracting personnel was later dropped to be more inclusive of other GS series as federal agencies increased the requirements for non-1102s to obtain their DIWEA or FACC certifications. Additionally, other federal buying activities, SBA staff, PTAC, SBDC personnel, who after hearing about the training requested access and were added to the list of participants. So that is why SBA's First Wednesday program is aimed at federal government employees and our resource partners like PTACs and SBDCs. Thank you to those of you who are repeat attendees, and welcome to those of you who are new to the program. On slide 2, as Carla mentioned, I am Chris Eischen, and I am a Procurement Center Representative, or PCR, with the Small Business Administration, and I am located in Kansas City, Missouri. Additionally, Ms. Deb Crumity, who is the PCR located at the Rock Island Arsenal, will be reading your questions submitted during the program for our speaker to address at the end of today's session. Slide 2 includes information. On to slide 3. Please note that all lines are on mute. However, you may submit questions anytime during today's session by entering them into the chat box on your screen, and these questions will be addressed at the end of our speaker's presentation. As most of you know, we have transitioned to the new WebEx application and have been informed that some users may experience issues such as a blocked website or other error messages when attempting to access the conference login from their computer. It is our understanding that your internal IT security settings are restricting your access, and the AT&T Help Desk or the SBA POCs identified on the login will be unable to resolve this issue for you. If you are affected by this issue, please make sure you're dialed in and follow along with the slides provided in the email. We will ensure the page numbers are clearly stated so you can follow along. We are hopeful this issue will be resolved for our next session, and we apologize for any inconvenience. Now, if you are having any other technical problems, please call the AT&T support desk at the following number, 1-888-796-6118. If you by chance didn't get that phone number for the AT&T support desk, it is located on the email invitation for today's program and on slide 3 of the PowerPoint presentation that accompanied the SBA email notifying you of today's training. Otherwise, just keep listening in and follow along with the PowerPoint that accompanied the invitation for today. As I mentioned earlier, we will continually announce the page numbers so you can follow along. For more SBA Small Business Program training, you can also visit the SBA Learning Center at www.sba.gov. Now on to slide 4. The Association of Procurement Technical Assistance Center, or APTAC, hosts a website where they post the first Wednesday programs. Since these sessions are recorded, you can re-listen to this program as well as the previous sessions by visiting their website, which is provided here on slide 4. Procurement Technical Assistance Centers, or PTACs, are a great resource, and partnering with your local PTAC for an industry day, sharing a sources sought, and RFI notices, or referring small business concerns to a PTAC are just a few reasons why they are such a useful resource for acquisition personnel. Please contact your local PTAC for additional information. Now on to slide 5. Slide 5 is the current program schedule for fiscal year 2018, and today's session on size and affiliation is the 7th topic of the series. As you'll see, we have added a couple new topics to our program list and improved on other topics that have been presented in the past. Last month's session of the Women-Owned Small Business Program was a huge success, as over 1,000 individuals participated in the training program. Your participation and positive word of mouth is appreciated, and we hope you find these topics interesting and applicable to your job. Slide 6. I'm sure that many of you will want to receive credit for attending today's training, so fortunately today's session is worth 1 CLP. I'll go into more of this detail on the next slide. So on slide 7 is the certificate you will complete with your name. First, you will manually fill in your name and then print the certificate from the PowerPoint to request credit for today's session. The PowerPoint was part of the SBA email invitation that you received for today's session. SBA does not track your CLPs or communicate with your training program regarding your CLP achievements. Several of you may have received the information for this training from a friend or colleague, but if you want to receive an email directly from us notifying you of upcoming First Wednesday webinar events, just email us at sbalearning@sba.gov. So that's sbalearning@sba.gov. In the subject line, please enter the words add to list, and we'll ensure you're added to the display. As I mentioned earlier on slide 7, this is the certificate that you will see. And please note that the only way you have the ability to print this out is having the original PowerPoint from the email that was sent out, and all you'd simply do is go to slide 7 where it says insert your name here, remove that information, put your name there, and you can either save as PDF or you can print it out and scan it in and submit it to your training coordinator, whoever you need to do that. So this is your 1 CLP, the certificate for that. On to slide 8. The topic of SBA size regulations is receiving a lot of attention in the world of small business, and today's training has been assembled to address several aspects of this topic. Our speaker has graciously accepted our invitation, and he will be directing me to continue to the next slide. As mentioned earlier, if you are unable to access the WebEx application, please follow along with the PowerPoint presentation that was included in the email regarding today's training. We will identify the page number so you can follow along. Also, please note that due to connectivity issues, some viewers may experience a delay as the slide changes on your screen. So I am pleased to introduce today's speaker to you, who is the Size Program Manager for SBA's Office of Government Contracting in Area 4 and hails from the Windy City, Mr. David Gordon. Dave, we appreciate that you could meet with us today, and I'll turn the program over to you.
Thanks, Chris, and thanks to everybody who's here. Just a couple of very quick preliminary notes, and then we'll get to the presentation. It is possible that questions will occur to you after the session today, or conceivably you may ask a question that we don't get to. I am happy to answer your questions individually if you want to get in touch with me, either by phone or email. Either one is fine. I'd far rather answer your questions in advance than wait till a problem arises and we need to solve the problem. So don't hesitate to get in touch with me if you have questions that weren't answered today or occur to you, later after you have had a chance to process what we've done and think about it a little. an hour is a long time to talk about size, but even so, we're only really going to scratch the surface. I went through my old presentations on this subject very carefully to make sure that the presentation was up to date and that it covered most of what I think arises in day-to-day dealings with issues relating to the SBA size regulations. There's no way we could possibly cover everything, and I apologize in advance. I talk quickly, and unfortunately I'm going to need to talk quickly to get through everything that we've got. So with that apology out of the way, why don't we go to the next slide, please, Chris? And what we're going to start talking about is, what is a small business? There is a basic definition in SBA regulations, and just parenthetically, note the bottom right of the slide. I've given you the CFR section, and on almost every slide I've tried to give you the section of the law, CFR Part 121 being the SBA size regulations, and the FAR regulation when there's an applicable FAR regulation as well. So I've tried to make it easy for you to follow up and see the exact language of the law on each particular item we're discussing. First of all, in order to qualify as a small business, a company has to be organized for profit. So the parenthetical means for-profit subsidiaries of not-for-profits are okay. Sometimes you'll run into a circumstance where the parent company is a not-for-profit, but it happens to have one or more for-profit subsidiaries. The parent can't qualify by definition as a small business, but the for-profit subsidiaries may. We determine whether a business is small or not by measuring its size plus the size of all of its affiliates. If it was simply a matter of measuring the size of a single company, size determinations would be simple. But the hard part of doing any size determination is determining whether the company that's at issue, generally in the form of a protest, has affiliates or not. That's a very complicated question. It often requires a lot of time. It certainly requires expertise, as you'll see from some of the slides that we discuss. One topic that has come up off and on over the years, but seems to be coming up with increasing frequency, is, can a foreign-owned company or a foreign-based company qualify as a small business? And the answer is maybe. And what I mean by that is the sheer fact, the simple fact, rather, that it's a foreign-owned company or a foreign-based company does not in and of itself disqualify the concern. For example, you may have a company that's based in Germany and they have offices or an office or a manufacturing plant or some sort of entity in the United States. It can be considered a small business so long as there is fundamentally, and first of all, a place of business located in the United States. And a place of business doesn't have to be a factory. It can just be a sales office. So they have to have a place of business, and then they need to meet one of two other requirements. Either they operate primarily in the United States, or they make a significant contribution to the U.S. economy. Now, significant contribution is relative. Obviously, a small business is not going to be able to make the kind of contribution to the American economy that Microsoft can. So it has to be considered, significant has to be considered as measured against the company's revenues. You compare the company, if you will, to itself. Is its contribution in terms of its own income significant? If I measure its contribution compared to Microsoft's income, there's not going to be a small business in the world that would qualify as being able to make a significant contribution. But if it has a place of business in the United States, and it makes a significant contribution to the American economy. And the way that's determined is by paying U.S. taxes or using American products or using American employees. Any one of those will qualify. But as you'll note, it's a multi-part test, and the concern has to meet each of the required parts in order to qualify. Can we go to slide 11, Chris? How do you know a business is small or not? We depend in the first instance on them. They have to self-certify when they submit an offer or a bid or a quote on a procurement. And the law requires that a contracting officer accept their representation unless the CO has a reason to believe otherwise. So if they have a listing in SAM where they represent their small, shall means must. Shall is a lawyer's word for must. So if they say they're small, you have to take them at their word unless you have a reason to believe otherwise. And the reason to believe otherwise has to be something specific. You can't say, gee, well, I'm not sure that they really qualify. I think I may have heard something. That doesn't work. It has to be a specific reason to believe that the representation in SAM is wrong. A contracting officer has the ability to protest a small business's representation, but it has to be a specific reason, a specific piece of evidence, a trade journal, a newspaper article, something that you can point to. The reason doesn't have to be right. In other words, you're entitled to make a mistake, but you have to be able to point to something. And the process is one that is intended to determine the size of the company that's in line for award. So if you have a group of 4 or 5 finalists and you're not sure that 1 or 2 of them really is a small business, you can't use the process to vet the offerors to give yourself a smaller pool of finalists. The only time that a competitor or a contracting officer can file a protest against another firm is to protest their nomination, if you will, as an apparent successful offeror. If you haven't opened bids yet, it's premature. If you haven't opened the bids, you haven't determined who the apparent successful offeror is, and so it's not timely to protest them at that point. Now, one other point, this doesn't really go here, but it's important enough to mention, so I've stuck it in here. We get a fair number of protests as well as from competitors, as well as questions occasionally from procurement personnel saying the company doesn't have the NAICS listed for this procurement in its SAM profile. That is irrelevant. It does not matter. There is no federal law or regulation that requires a company to list the NAICS assigned to the procurement in SAM unless the solicitation actually requires it. And I can tell you I've never seen that happen. It certainly could happen. Most solicitations don't address the issue at all. The few that do only say that the company has to have the appropriate NAICS listed before award. So you tell them that award is contingent upon their updating their SAM profile, and odds are they'll put the required NAICS code into their profile. But it's not a prerequisite to offer or bid on a procurement. Next slide, please. 12, Chris. Again, this slide doesn't really fit right here, but it's too important a topic to not address. It was a big issue for a while. It seems to be quieting down, but that first bullet is critical. A wholesale or retail NAICS code cannot be assigned to a federal procurement for supplies. The reason is a simple policy reason, and that is the government wants the largest possible audience of potential offerors or potential bidders. And if you just put down a wholesale or a retail code, then you're omitting manufacturers. But if you list a manufacturing code, in the first place, you're opening the procurement up to anybody who manufactures widgets. The non-manufacturer rule, which is a specific SBA rule designed to address this situation, provides that wholesalers or retailers or distributors can bid on a procurement which has been assigned a manufacturing code if they meet certain criteria. We're not going to have time to go through the non-manufacturer rule today. As a matter of fact, I think Chris has arranged earlier this year for an entire presentation to be given on the subject. It's not a terribly complicated rule, but it's a very important one, and it's one you should be familiar with, at least a simple sense of knowing that it exists. And it exists, again, for the policy reason of making the potential bidding or offering pool as large as possible. This last bullet, I don't want to mislead you by saying that the size standard for procurements of supplies in those NAIC sectors is 500 employees. All that means is if a wholesaler or a retailer is going to bid on a procurement under the non-manufacturer rule, their size standard is going to be 500 employees, regardless of what the manufacturing size standard is assigned to the procurement. Okay, Chris, slide 13, please. This topic comes up from time to time, both from procurement personnel and from small businesses themselves. SBA does not certify businesses as small. There's something like 27 or 28 million small businesses in the United States. I have about, 10 colleagues who do the same kind of size work I do. I don't know what 10 into 28 million is, but it's a bigger number than I could do in a year. And so we have self-certification. SBA relies on, well, two things. It relies on the innate honesty, I'd like to think, of small businesses, and it also relies on federal perjury statutes. But the more important point here is small businesses, as a general rule, self-certify. SBA will not certify them. The exception is the two programs that involve an entire formal application process. It can be done online, it can be done on paper, but the 8A program, which is a minority small business development program, and the Hub Zone program, which stands for Historically Underutilized Business Zone, both of those programs require as a criterion for admission that the company demonstrate that it's a small business. So in those two programs alone, as part of the admission process, SBA personnel in those programs will be checking to make sure that the company qualifies as a small business before it can even get into those programs. So as a general rule, and I'll explain the exception in a second, you can depend on the fact that someone who's an 8A firm or a Hub Zone firm has already been reviewed by SBA and found to be small. Now, the reason I say that there's an exception is those are multi-year programs. Things have a tendency to change. And so it is possible that a company that qualified as a small business when it entered the program no longer qualifies. So looking on SAM and seeing that they're an 8A or a HUBZone firm is a pretty strong indication that they qualify as a small business. It's not an absolute guarantee, however. You are entitled to rely on it. If they self-certify that they're small and you see that they say they're an 8A firm, you can rely on all of that. I'm just pointing out that on occasion, and it's a pretty rare occasion, there may be a circumstance where a company is no longer in compliance. So if it's not 8A and it's not HUBZone, all other types of businesses self-certify. SBC stands for Small Business Concern. Women-owned and veteran-owned SBCs all are responsible for certifying themselves as small. Slide 14, Chris. Congress granted SBA the authority to conduct formal size determinations in two categories of cases, requests and protests. Requests, for the most part, are internal to SBA. There are certain provisions in the request portion of the regulation that carve out exceptions, like we can do small business determinations for the Patent and Trademark Office. But as a general matter, requests relate to internal SBA program matters. The portion of the regulation that will be most important to you is the protest portion of the regulation. And here again, let me emphasize, we can only do determinations where Congress has given us the authority to do a determination. So, for example, Congress has not given us the authority to take a protest off the street. If ABC Small Business, for any reason, has evidence that XYZ small business may not be small, they cannot simply send a protest into SBA and say, we want a size determination. We can't do that kind of determination because we don't have the legal authority to do that kind of determination. There is a provision that allows SBA to initiate its own determinations, and on occasion that kind of off-the-street protest may be picked up by an area office depending on the nature and probativeness of the evidence, but it's a fairly rare thing. For the most part, protests relate to the 13 categories, relate to the 9 categories of protests authorized by our regulations. And the only people who are eligible to file a protest are going to be set out for each one of those 9 categories. So, for example, small business set-asides, plain vanilla, total small business set-asides. There are 4 categories of parties that have the ability to file a protest. Basically, the first one is competing offerors who didn't get an award, the CO, certain parties at SBA, and other interested parties. And in this case, interested parties relates primarily to a very peculiar situation involving large businesses and shouldn't be construed as sort of a catch-all for anybody who has an interest in the procurement. Slide 15, Chris. Which protests have to be sent to SBA? And the answer, which size protests? And the answer is all of them. You may be absolutely convinced looking at a protest that they've either nailed it and they're 100% correct, or conversely, that the person filing the protest is completely wrong and that there's absolutely no way that the protested firm could not qualify. It doesn't matter. Size protests are handled exclusively by SBA. A contracting officer does not have the right to decide a size protest. Procuring agencies have the ability to decide Part 33 protests. There are also status protests. For example, a protest comes in and says they're claiming to be an 8A firm. We don't think they're a bona fide 8A firm, or we don't think they're a bona fide eligible hub zone firm. Those protests are handled elsewhere, not in the area offices, but size protests are handled only in SBA area offices. And so that's why I have in parens and in capital bold red letters, not district offices. From time to time, procurement people don't consult the FAR and say, well, I know it's SBA, so I'm going to send it to the local SBA office. Please don't. Please read the FAR. The FAR and the CFR both are absolutely clear on where size protests get sent, and that's only one place. It's the area office that has jurisdiction over the state where the protested firm is located. Doesn't matter where the protester is, doesn't matter where the contracting officer is, doesn't matter where performance is going to be. It's the state where the protested firm is located. And if a protest is sent to another office, multiple things can happen. I have had them look at the package in a district office and say, what's this? I don't know what to do with this. And a month went by in one case. You're going to save everyone grief if you send it to the right office in the first place, and that's always only going to be an area office. Okay, Chris. Next slide, slide 16, please. Most size determinations take 15 business days. That's what the law prescribes, both in the FAR and in the CFR. If it's a fairly simple, straightforward dismissal, and we'll talk about those in a minute, they generally take a lot less time. It's going to depend in part on how busy the office is and how complex the case is. There are increasingly cases that are so complex they can easily take more than 15 business days. As you'll note, my third bullet says, if you've waited 15 business days and cannot wait any longer, the FAR provides, and I've given you the site, that if there is a formal decision in writing that there is an immediate need to award the contract and that waiting will be disadvantageous to the government, you can go ahead and make the award without waiting for SBA. I am not aware of more than a tiny handful of those cases ever happening. It's not to say that the procurements aren't important and don't need to be made timely, but size determinations can be extremely complex and they don't always lend themselves to artificial deadlines. Sometimes the small business will request an extension to submit its initial paperwork. Sometimes the SBA office you're dealing with will request an extension. We try to get things done as quickly as we can, but we can't always do it within 15 business. Only you know how imperative your procurement is. So if you get a request, all I would suggest is please consider it carefully. There's generally a very good reason for the request. If you can spare some time, great. If you can't, you can't. We're not asking for the impossible, but we are asking for consideration when it's reasonable to grant an extension. My experience has been everything from not another 10 seconds to take another 2 weeks. It all depends on the procurement. Only you know how urgent the procurement is, and that's why SBA does not have the authority to grant an extension. Only the procuring activity can do that. Slide 17, please, Chris. I've already mentioned the first bullet. We can't use size protests to vet finalists. The second one I've also mentioned, they cannot come off the street because we don't have the authority to take them from off the street. They have to be made in connection with a particular procurement. That's the language of the regulation. We also get calls, or at least this office does from time to time, saying, hey, we're looking at these companies. We don't need a formal determination, but can you consult your secret database and tell us whether this company is small or not? And the answer is, love to help you. I can't. We don't have a secret database. When I have questions, I go to Sam just like you do. And even if I've done a size determination on the same company last year, the results of that determination were valid for when that determination was done. Anything could have happened in the meantime. They could have been acquired by Microsoft. They could have acquired other companies themselves. All kinds of stuff could have happened. So the fact that we may have recently done a determination won't tell us a thing. Okay, slide 18, please, Chris. A protest has to be timely. And in that regard, I have to point out that a protest goes to the CO. Protests do not get mailed to SBA. It doesn't happen often, but every once in a while you've got a protester who doesn't know quite what's going on, and they may call the CO or call the procurement people and say, what do I do with this? The answer is the protest has to go to the CO, and the CO has to get it within 5 business days of either notification to unsuccessful offerors, in the case of RFPs and RFQs, or 5 business days after bid opening. I suppose there's probably a third category that doesn't fit either one of these, when sometimes, depending on the size of the procurement, depending on the agency, there is no actual notification to unsuccessful offerors, but notice of award is posted. In that case, it's 5 days from the time notice was posted. As I said before, a protest has to be specific. If a protest is not specific, we will dismiss it. An example of a protest that's not specific, ABC Company is not a small business. And that's the gist of the protest. I should say that there are no magic words. You don't have to use the word size protest in the protest itself. You just have to allege, or the person protesting has to allege, that the business being protested is larger than the size standard assigned to the procurement. And there has to be some specific basis. Again, don't have to be right, but have to be able to point to something. And the reason boils down to due process. The protested firm has a right to know what the claim against it is, and without knowing what the claim against it is, it has no way to respond. If it sees that you're claiming that they're large because of X article, then they know what the issue is that they're addressing. But a protest that just comes in and says, I don't think they're small, doesn't specify why they're not small, and so will be dismissed. Slide 19, Chris. Generally speaking, different area offices handle this slightly differently. In Chicago, we will make sure in the first place that the protest is timely and that it's specific. Only at that point will we contact the firm. If it's not timely or it's not specific, we'll dismiss it. There's no need to talk to the company because the protester didn't meet the basic criteria to get in the door. Now, from time to time we get calls or emails or questions from procurement personnel. Can you please expedite this? It's a critical procurement. The answer is no, I can't. And the reason is, number one, the odds are there are a handful, if not a large handful, if not in some cases an extremely large number of protests pending in the office at the same time. You don't want me to jump ahead of all the other protests that came in before yours because it's not fair and it's not right. You wouldn't want to be jumped over, and neither does any other procuring officer who's got a protest pending want to be jumped ahead. We do our best to get to them as quickly as possible, but saying expedite it is really asking for a next to impossible thing, because basically it's saying, I don't care that you have other procurements in front of ours is more important. Well, yes, I understand that, and yes, it is to you, but no more important than the protests and cases pending for the COs who already have matters pending here. We do our best to get it done on time. As a matter of fact, there is a metric that we are all judged on dealing with our timeliness in handling size protests and issuing determinations. We will get to it as quickly as we can, but we can't work miracles. And that's the next bullet. It's very difficult, if not flat out impossible, to give any kind of a useful update. And that's because the facts change. It is typical in the course of a determination for questions to be sent to the protested concern to clarify things, and I can recall more than one or two cases where literally the direction that the determination was taken changed from day to day. There's no way to predict how it's going to turn out until it's done. So the only conceivable update we could give you is there are 15 cases ahead of yours, or there's one case ahead of yours. But in terms of where it's going to go and how it's going to turn out, it's really impossible to say. When it's done, copies are sent automatically to the protester, to the protested concern, and to the CO. As soon as it's done, we send them out. Slide 20, please, Chris. Size is determined as of the date that the company submits its written self-certification that it is small to the procuring activity as part of its offer. What that means in practice is the date that the company signs its offer, or the date that it submits its bid. It may become large after that and still be eligible for award. Now, as you see in my parenthetical, there may be some wiggle room there for cases involving merger negotiations, but as a general matter, if it was small on the date that it's self-certified, it will still be eligible for award if it becomes large after that date. Slide 21, please. The exception, the important exception is, I've listed them there, there's three of them: novations, mergers or acquisitions without novations, and long-term contracts. If it's no longer small because of a novation or a merger or acquisition, the CO cannot count the contract toward the agency's small business goals, but our regulations don't contain any requirement to terminate the contract. That's up to you. We can't tell you to terminate your contract if a company becomes large. If exception 3 applies, and that's by far the most common exception, it's a long-term contract. Let's say toward the end of the 5-year period, before the first option is exercised, the CO has to go back to the company and say, we need you to recertify yourselves as small, or we need you to certify yourself whether you're small or not. We need some sort of an answer. And again, in that case, it's up to the contracting officer what he does with the contract, but the recertification has to be made by the small business in the circumstance of a long-term contract. Slide 22, please, Chris. Size, as I mentioned early on, is determined by adding together the size of the small business firm that's being protested plus the size of all of its affiliates. How do you know who its affiliates are? The key to affiliation is control. Concerns are affiliated with each other if one concern controls or has the power to control the other, or if a third party can control both. Please note the bottom bullet there, separate divisions, subsidiaries, all of those things are irrelevant. Slide 23, Chris. Those are the tests we go through when we're determining whether control exists with relation to other firms. Do the people who control the protested firm control other firms? We look at questions of negative control, potential control, identity of interest, common management. All of these are potential ways for control to arise and therefore for affiliation to arise. Chris, go ahead to slide 24, please. Here's the simplest kind of analysis, stock ownership. I own those specified interests in each of the following companies: 100% of an ice cream parlor in Chicago, 50% of a furniture manufacturer in Tibet, 75% of a machine shop in Ohio, and 45% of a construction company in Montreal. None of those businesses do any business with the other. The only thing they have in common is that I own them all. I control them all, and because I control them all, they're affiliated with each other. It doesn't matter that they're in different countries. Doesn't matter that they do different things. Doesn't matter that they don't do business with each other. Now, you'll notice that I highlighted the 45% in red because, as you can imagine and are probably saying to yourselves, well, it depends. If I own 45% and the other 55% is split among 55 different people, clearly I have the power to control because my block is 45 times larger than the next largest block. If I own 45% and someone else owns 55%, then they control. If I own 45% and somebody owns 25% and somebody owns 20%, it gets a little grayer. And you can imagine, anytime there's no single majority owner, the analysis can be fairly complicated. The rules themselves with relation to stock ownership are fairly complicated because unless you have a single majority owner, the circumstances can be very complicated. But the point of this slide is simply to illustrate it's control that matters. Slide 25, please, Chris. Joint ventures and teaming. Let me take teaming first, which is the last bullet point. The lawyer in me hates the idea of teams. And the reason is very simple. There is no legal entity called a team. A team is an artificial construct. A team can be either a joint venture or it can be a prime and a sub. There's nothing else it can be. But telling me that there's a team tells me nothing. It tells me that there are firms related to each other somehow, and telling me that it's a team doesn't tell me what I need to know. What I need to know is it a joint venture or is it a prime and a sub? So teams exist. There was a period of a number of years where SBA actually took all references to teaming out of its regulations because it's such a nebulous word and because it doesn't really help, but it's creeping back in. And I know it's a fairly popular concept out there. That's fine, but teaming in and of itself is not a useful description because it doesn't tell me about the nature of the relationship between the firms involved in the team. Now, if we're talking about a joint venture, that's different. A joint venture is a legal concept. It has a certain definition, and it's fairly easy to understand how joint ventures work. Now, for purposes of SBA and size rules and size determinations on procurements, if the offeror is a joint venture, first rule, the joint venture has to be in writing. Joint venture agreement has to be in writing, and the entity has to do business under its own name. It has to be identified as a joint venture in SAM. It can be organized in multiple ways. It can be a corporation. It can be a partnership. It can be an LLC. The form of legal entity doesn't matter, but the entity has to be its own separate legal entity. Now, it can only be populated by individuals who are going to perform administrative functions. In other words, not people who are going to perform the contract itself. So you can have the bookkeepers employed by the joint venture, but you can't have the construction engineers employed by the joint venture. There was a change in the rules about a year and a half ago. The third bullet, it's an extremely important change. It used to apply in a subset of cases. Now it applies across the board. If each joint venture partner, whether it's 2 joint venture partners or 5, if each one of them individually qualifies as a small business under the size standard assigned to the procurement, then the joint venture itself will be considered to be small. And I've given you the citation there. Okay, can we go to the next slide, Chris, 26? There's all kinds of complicated and detailed rules dealing with 8A joint ventures. There's even all kinds of detailed rules dealing with mentor proteges. But I want to hit it very briefly because it does come up frequently, and it's worth hitting briefly so you've got some very basic understanding of what this is. If an 8A participant in the 8A program gets together with its SBA-approved mentor, it can create a joint venture to bid as a small business for any federal procurement, so long as the protege is small, which it should be by definition because the protege is an 8A firm and it should be small to be in the 8A program. So even if you've got a small 8A protege in the 8A program, it can partner with its mentor Microsoft or General Motors or General Dynamics to perform and still be considered a small business so long as several things happen. First, SBA has to approve the agreement between the mentor and the protege, talking about, among other things, the kind of assistance the mentor is going to provide. And the joint venture agreement also has to be approved by SBA before the bid or the offer is submitted. Approval afterwards is not good enough. If it's not approved before they submit their offer, it doesn't get the protection of the safe harbor. Now, another thing to keep in mind, it's a safe harbor and it's a pretty expansive one, but it only applies to the assistance that the mentor provides under the agreement. The agreement is required to specify certain kinds of assistance, and as long as the assistance is limited to what the agreement provides, no affiliation will be found. However, affiliation could be found for other reasons. If, for example, there's common management or common ownership, the possibility of affiliation in spite of the mentor-protege agreement still exists. Please remember, too, that within the past year or two, we've started an all-small mentor-protege program for non-8A firms, as well as retaining this program for 8A firms. Slide 27, please, Chris. Very important rule. I'm plucking it out of obscurity. Well, maybe not obscurity. If you have a prime sub-arrangement where the prime is a small business and they're basically a pass-through, where, in other words, the ostensible subcontractor is the tail wagging the dog, that's prohibited by SBA regulations. The rule is the prime has to perform the primary and vital requirements of the contract. The prime cannot be unusually reliant on the subcontractor. If the parties violate that rule, they will be considered affiliated and may not qualify as a small business. The key is who's doing what? Is the tail wagging the dog? Is the sub really running the contract? We look at a whole slew of things. These are extremely complicated cases. There is no simple way to look at a prime sub arrangement and tell just by looking at it who's running things. But remember, if the sub is running things and is a large business, it's going to be affiliated with the small prime and be ineligible for award. Next slide, please. 28, Chris. There's also another change, last major change to the regulations recently. Similarly situated entities, firms that meet the same size and status requirements as the prime contractor. So if you have a hub zone set-aside or an 8A set-aside and they engage a subcontractor who is similarly situated, in other words, another 8A firm or another hub zone firm that qualifies as small under the size standard assigned to the contract, they will be exempt from a finding of affiliation with the prime under the ostensible subcontractor rule that I just mentioned. It's a very important exception. It applies only to similarly situated entities, and I've given you the regulatory site so you can read the definition. Slide 29, Chris. Actually, I'm not going to take the time to go through this. It's important. It tells you once a determination is issued, what does that determination mean? How does it affect the small business? How does it affect your procurement? Take a look at that slide. Take a look at those regs. Very important stuff there. Slide 30, Chris. I think that's it. I've left out some incredibly important stuff. I haven't talked really about the non-manufacturer rule, limitations on subcontracting. I haven't talked about the adverse inference rule. There's a lot of stuff out there, and as fast as I've talked and as much as we've covered, we've got very little time left, and I apologize for that. I think the next couple slides are simply contact information, tells you which area office has jurisdiction over which states on that slide, and the last slide tells you who has jurisdiction for status or eligibility protests that we talked about before. And with that, I'll stop talking for a minute.
Okay, Dave, thank you so much. Deborah, I think we are ready for some questions here. We've got a few minutes. We can knock some out, so if you want to start reading some of those.
Sure, Chris, thank you. Dave, we did have a question in the beginning about verifying the self-certification if they don't have a particular NAICS code listed in SAM, and I think you mentioned that about the solicitations. Can you clarify that a little bit?
Well, if the odds are they've got some NAICS codes listed in SAM. So if they're small for any NAICS code that has the same size standard, the odds are they're going to be small for the same size standard with a different code. So look for any code that has the same exact size standard. If it's not there, then you're going to need to tell them to either enter the code and certify in SAM or to get some sort of certification to you some other way. Okay, Deborah.
Thank you. One more question. If a company say it's small under size standard based upon the number of employees, however, in reviewing documentation submitted, seeing more than 1,000 employees mentioned, is that a valid reason to believe the self-certification is wrong? And Sam?
It is absolutely a valid reason. What I generally advise COs to do in that case is call them up and get some sort of written explanation. Sometimes it's a simple typographical error that has happened a number of times. People do make typing errors, transcription errors, whatever. But if they're unable to resolve the discrepancy to your satisfaction, that is sufficiently specific to go ahead with a protest.
Okay, thank you, Dave. Chris, should I continue? Hello?
Yes, sorry, I was on mute. Sorry.
Okay.
Yeah, let's do a couple more if we can.
Sure. Okay, number 3, Dave. This one talks about NIC 541519, the ITV retailer. It states, I think, in SBA size center table, 150 employees instead of 500. So can you talk about that a little bit?
I'm not quite sure what there is to say, except that's a carve-out, and my recollection, I don't know it off the top of my head, is that there may be other language. There's a footnote to the size table that has that, and I think it talks about some other conditions. I could be wrong, but yeah, there's that. 150 employees is 150 employees. So for that particular carve-out, for the nature of work done that's described in that footnote, so long as it's precisely the work that's described in the footnote, then the size standard will be 150 employees.
Okay. And SBA size table lays that out in the footnote. It talks specifically about the percentages of work. Moving to the next question. If a company registered in SAM using 2 different addresses and DUNS, can both locations be HubZone certified and 8A certified? If so, how and why? When there's only one location, when only one location is HubZone.
I don't know the answer to that. I wouldn't see any reason why an 8A firm and a HubZone, why a firm couldn't be both. HubZone is based in part on geographical criteria. 8A is based primarily on economic and social disadvantage. So their entry into the programs, to my understanding, and I am not an expert in this, is based on different criteria, so I don't know any reason off the top of my head why a firm couldn't qualify as both.
Okay, thank you, Dave. This next question relates to joint ventures. Reviewing past performance, is it allowed to specify that only past performance as the joint venture company be allowed versus joint ventures submitting past performance individually?
No, you can't require a joint venture to have past performance for the simple reason that joint ventures are often created specifically for the purpose of bidding on that procurement. And in fact, if you go to FAR 9.104, which talks about the criteria for responsibility, it specifically says that you cannot require past performance and hold the lack of it against an entity because an entity may be brand new. So in that case, I mean, you can ask them or require them to submit evidence of past performance if they have any, but if they don't, which is certainly conceivable to me, then you'd have to ask them to submit past performance for the component entities to the joint venture.
Correct. Thank you, Dave. This next question, I think you talked about it in your presentation, but can you elaborate a little bit more about if the CO if a contract is for 10 years, should the CO have been self-certified after 5 years?
I'm not certain I understand the question, but if it's a long-term contract where you've got a, say, 5-year base period and any number of options, they're required to request, COs are required to request recertification prior to exercising any option beyond that 5-year period. So if it's 5 1-year options, 5 5-year options, each time there's an option, there has to be a request for recertification, if I understand the question correctly.
I believe that's correct. The question is say 5 years, and then 10-year total, so I would think it's the base 5 years. They didn't really say. The next question, can you clarify a nonprofit? Ability 1, small business must be noted as large. I'm not clear. I'm not really sure on this question, and if you could just add additional information, the person that answered this that asked this question, it's not really clear.
I'm looking at the question that was typed in too, and I don't understand it, honestly. A not-for-profit cannot, by definition, be a small business. That's something I think I said on the first or second slide. It's a definitional requirement. If you have a business that is organized as a not-for-profit under state law, they cannot qualify as a small business concern, period.
Okay. Thank you, Dave. Now, on the next question, could you please send yes, we will send the PowerPoint. I think that may be all of the questions. Chris, do you see if I missed any? I think, let me just go back just to make sure.
Well, what we can do, too, is if we did miss some, we'll reach out, and I believe we have individuals with their name, and the email address is also provided. So that's one way we could follow up as well if we need to. We are a little over time, Dave. Thank you so much for sharing your knowledge with us and all this great information. Like you said, it is only an hour, and as the slide showed, there's definitely more information. I know you could talk for multiple hours, so maybe next time we'll have 2 hours for you. So also, I want to appreciate all of the participants on our call and who are able to log in. Once again, appreciate your participation and look forward to the continued participation coming in the next month. And thanks again.
Thank you all for joining today's conference. The session has now concluded, and you may disconnect.